My name's Carl Johnson. I'm a partner at Stephensons and I'm head of the firm's regulatory department. I specialise in professional discipline and regulation. Professional discipline is the process by which regulators and professional bodies take action against the registration of their members. This may be for a variety of reasons, including deficient performance, allegations of misconduct both within and outside of a professional's practice, or concerns about a professional's physical or mental health. A regulator will normally consider whether it's necessary to take action in order to uphold standards of behaviour, to protect members of the public, or to uphold the good reputation of a profession. Our regulatory team act for a wide range of professional clients. We regularly act for doctors who refer to the GMC, dentists refer to the GDC, pharmacists refer to the GPHC. We act for chartered accountants facing action by ACCA, ICAEW and CIMA. We act for nurses and midwives referred to the NMC, a wide range of health professionals who are referred to the HCPC, and we act for psychotherapists facing action by the BACP, BPC and UKCP. Well, professional discipline, by its very nature, is wide-ranging. As such, we have experience of dealing with a very wide range of allegations. These will include issues that are directly connected to a professional's practice, such as poor performance, failing to comply with their professional obligations, errors leading to significant adverse outcomes to patients and clients, and misconduct in the workplace, such as dishonesty, sexual misconduct, and bullying and harassment. It also includes issues in a professional's personal lives, which may either cast doubt on their suitability to remain a member of the profession or may adversely affect the reputation of the profession, some good examples being criminal convictions and misconduct on social media. When dealing with most regulators, there are two principal stages to a case: investigation and adjudication. During the investigation stage, a regulator will effectively build their case, and that involves taking witness statements, obtaining evidence from a complainant or referrer, possibly instructing an expert witness, and requesting information or documents from the practitioner themselves. In the case of a number of professions, they are obliged to cooperate with those requests for information. At the conclusion of an investigation, a professional will normally be afforded the opportunity to respond formally to draft allegations and make submissions in relation to the case which has been presented. This is a critically important stage in a professional disciplinary case because many cases can be resolved at the conclusion of the investigation, either with some sort of warning or reprimand being issued, an agreed outcome in relation to sanction, or with the case being dismissed altogether. In the most serious of cases, provided that a regulator has been able to demonstrate that they have a realistic prospect of establishing their case, this will be referred to a formal fitness to practice or professional conduct hearing. Hearings will take place before specialist committees and tribunals who must determine whether A, the allegations which have been made are in fact proven, and B, if so, what action ought to be taken against the professional's registration. The professional has the right to attend their hearing, to be legally represented, and to call witnesses in their defence, and we will almost always advise our clients to engage fully with the process and attend their hearings. Regulators and professional bodies have a number of powers at their disposal at the conclusion of a matter. These include power to issue warnings or reprimands, to impose conditions on a professional's registration which allow them to continue in practice but on a restricted basis. And in more serious cases, regulators have the power to either suspend registration or membership or remove a professional from their profession altogether. As such, the most serious of cases have the potential to be effectively career-ending. Given the sanctions available to regulators, these cases often involve high stakes and the implications to a professional's livelihood and reputation can be extremely serious. A specialist lawyer can draw on their experience to guide you through the complicated regulatory process. Stephensons have extensive experience of this area of work, and we provide pragmatic and sensible advice to our clients. We advise our clients where we think that allegations should be admitted, and our focus should be on mitigation, remediation and insight. We also advise clients where we think a case should sensibly be defended, and we'll advise them on how to best go about mounting an effective and successful defence. It's worth noting that this area of law involves cases which are often highly emotionally charged. We recognise that to be under scrutiny by your regulator or your professional body can be extremely stressful and daunting. A specialist lawyer can provide a much needed barrier between you and your regulator and can help absorb some of that pressure and stress. So if you find yourself the subject of a professional disciplinary investigation, we have a team of dedicated lawyers ready to fight your corner.